Good afternoon. Circuit Court for the 6th Judicial District, Campbell County is in session. It is the 25th day of September 2025. We are here today in CR 2025-0482. This is captioned the State of Wyoming versus Gerald Hamlin. On behalf of the state, I have Ms. Gibbs. On behalf of the defense, I have Mr. McVeigh, who's appearing by video. And Mr. Hamlin, would you please state your name for the record, please?
Gerald Hamlin.
All right, Mr. Hamlin, I'm going to have you stand and raise your right hand. I need to swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you give will be the truth?
Yes, ma'am.
All right, thank you. Please be seated. All right, this case is set for a change of plea. Is there a plea agreement?
There is, Your Honor. The plea agreement would include that Mr. Hamlin would plead to the possession of marijuana charge. The state would recommend 30 days, given credit for any time served, the remainder time suspended, in exchange for 6 months of unsupervised probation with standard terms and conditions, and leaving any financial obligations up to the discretion of the court.
Okay. And I did fail to mention there's a, we're also set for bond revocation hearing, but if we proceed with the change of plea, that makes that moot. I just want to make sure that we're addressing all of that. Mr. McVeigh, is that your understanding of the agreement?
Thank you, Your Honor. That is my understanding of the agreement, and my client is ready to proceed forward with the actual change of plea in this matter. And it is correct that the bond revocation will be rendered moot, so to say, and that was discussed between myself and Mr. Reed, and also included in the email chain as well. My client is concerned about the bond amount as well. He was afraid of that being forfeited, but my understanding is that would not be forfeited under this plea agreement.
All right, Mr. Hamlin, is that your understanding of the agreement?
Yes, ma'am.
All right, sir, are you currently under the influence of any alcohol, drugs, or any other intoxicant?
No, ma'am.
Are you taking any medication which would affect your ability to understand these proceedings?
No, Your Honor.
Do you suffer from any mental illness or deficiency that would affect your ability to understand these proceedings?
No, Your Honor.
Is there anything I haven't asked you about that would affect your ability to understand what we're doing today?
No, Your Honor.
All right, sir, how old are you today?
I am 35.
How far did you go in school, or what level of education do you have?
Some college.
Are you currently employed?
Self-employed.
Okay, what's your business?
Skilled Tradesman Association.
All right, sir, it looks like you were arraigned on May 6, 2025. At that time, the judge would have went through your constitutional rights with you, would have went through the charge and the maximum possible punishment. Do you remember that?
I don't recall.
All right, sir. Do you understand that I'll go through the rights with you here? You may plead guilty, not guilty. Not guilty by reason of mental illness or deficiency, or with the permission of the court, you may plead no contest. You are presumed innocent of any wrongdoing, and that presumption follows you throughout trial. You do not have to prove your innocence. The state must prove your guilt beyond a reasonable doubt. You have the right to remain silent. If you give up that right and answer any questions or make any statements, anything you say could be used against you in court. If you plead not guilty, you have the right to a speedy jury trial. If you wish, you may give up your right to a jury trial and have the matter tried to a judge. At any trial, you have the right to confront and cross-examine the state's witnesses. You also have the right to call witnesses in your defense and use the court's subpoena power to compel the attendance of witnesses. At trial, you have the right to testify or not as you choose. If you choose not to testify, nobody can hold that against you in deciding your case. If you are convicted after trial or plea, you have the right to appeal the conviction or sentence by filing an appeal within 30 days of entry of the final order. If you cannot afford the cost of an appeal, you can request leave to file the appeal without paying a fee. At all critical stages of the criminal proceedings, including appeal, you're entitled to be represented by a lawyer, or you can represent yourself. If you cannot afford the cost of a lawyer, you can apply for a court-appointed lawyer. Those services are not free, and you may be required to pay back all or a portion of the cost of the public defender. If you're currently on bond, probation, or parole, a guilty plea may be used to revoke that bond, probation, or parole. If you are not a United States citizen, a conviction could result in deportation proceedings. In addition to any fine, you may be assessed a crime victim compensation fee of not less than $150, court costs in the amount of $70, treatment court surcharge of $50, and restitution is if that is requested. If you are convicted of a violation of the Wyoming Controlled Substances Act, you may lose federal guaranteed funding such as student loans or housing. Do you have any questions about any of those rights, sir?
No, Your Honor.
All right, sir, the charge is a violation of Wyoming Statute 35-7-1031C1A. That statute provides it's unlawful for any person knowingly or intentionally to possess a controlled substance unless the substance was obtained directly from or pursuant to a valid prescription or order of a practitioner while acting in the course of his professional practice. No prescription or practitioner's order for marijuana, tetrahydrocannabinol, or synthetic equivalent shall be valid. Here, the state alleges that you had a controlled substance in plant form, no more than 3 ounces. That is punishable by up to 1 year incarceration, up to a $1,000 fine, or both. Do you understand the charge, sir?
I do.
Do you understand the maximum penalty?
I do.
All right, sir, do you understand that by pleading guilty that you will be admitting to all the essential facts of the charge?
I do.
Do you understand you'll be giving up certain rights, such as any defenses that you might have, the right to remain silent, the right to a trial, and you will be relieving the state of its burden?
I do.
Do you understand you will be asked questions under oath and any false answers could later be used in a perjury prosecution?
Yes, ma'am, I do.
Do you understand there'll be no trial of any kind and the only issue left will be sentencing?
Yes, ma'am, I do.
Do you understand the plea agreement is just a recommendation to the court, not a promise of what the court will do, and that I can sentence you up to the maximum allowed by statute?
Yes, ma'am, I do.
And do you understand that if the court rejects the plea agreement, that you cannot withdraw your guilty plea?
Yes, ma'am, I do.
All right, sir, other than for this charge, are you currently on any sort of bond, probation, or parole?
No, ma'am.
Other than the plea agreement, has anyone promised you anything in exchange for your guilty plea?
No, ma'am.
Has anyone threatened you or forced you to get you to plead guilty?
No, ma'am.
Have you had enough time to talk with Mr. McVeigh about your case?
Yes, ma'am, I have.
Has he answered any questions that you have had?
He has. I'm still looking for discovery for this last arrest on the case.
Your Honor, he's talking about the bond revocation discovery for the police pullover. I've submitted a subsequent request for discovery. Mr. Reed is currently at, I think, the conference, but that has been delayed, and I see that forthcoming without issue. But all discovery in regards to the charge, as alleged that he be pleading to, has been provided over, Your Honor.
Okay, and if we proceed with the change of plea today, the bond revocation becomes moot because there is no bond in place anymore.
I understand. I just want the discoveries for futures. I've spoke with my attorney, but I would like those videos for future purposes.
All right, Mr. McVeigh, are we proceeding with the change of plea with that outstanding?
I would be comfortable with that, Your Honor. I have submitted it, and Mr. Reed has not had a chance to respond back to me, but it has been supplied, and they do know I've requested that body cam footage.
Is it the state's intent once the discovery, once this case is closed and the discovery rules no longer apply, to supply that information?
Your Honor, if the defense wants the discovery, I don't think we'll have an issue giving that, especially since it was something related to this case, even though it is now deemed moot. The state has no issue holding up, that obligation, even if it technically wouldn't necessarily be part of the rules after it becomes moot, but we'll still ensure that that gets over to them as it was part of their request.
Okay.
Thank
I
you.
just want to make sure that everybody's on the same page here, so. All right. All right, have you had enough time to talk with your attorney?
Yes, ma'am.
Has he answered any questions that you have had?
Yes, ma'am.
Are you satisfied with his services?
Yes, ma'am, I am.
All right, sir, as to the charge that on or about the 5th day of May 2025 in Campbell County, Wyoming, you committed a violation of Wyoming Statute 35-7-1031 C1A Possession of a controlled substance in plant form, 3 ounces or less. How do you plead?
May I plead no contest?
The parties put on the record here that the agreement was for you to plead guilty, Ms. Gibbs.
Your Honor, that is not part of the agreement at this point. That would have to, go through renegotiations. I would have to defer to Attorney of Record Dan Reed, as he was the one who did initially negotiate this offer.
Okay.
Mr. McVeigh, do you need a moment with your client?
I plead guilty.
Thank you, Your Honor. In regard to your question, I understand this was not discussed as a no contest. It was discussed as a guilty. My client is relayed that he would plead guilty to it, and it would be a very succinct, simple, factual basis that I would like to go through with him for the purposes of the court, Your Honor.
All right, you may proceed with factual basis. Thank you.
Thank you. Sir, can you please state your name for the record?
Gerald Hamlin.
Thank you. And Mr. Hamlin, were you present in Campbell County on May 5th, 2025?
I was.
And did you subsequently have police interaction on that date?
I did.
And due to that investigation and their search of your residence, did they find the alleged plant form in regard to the matter being an illicit substance of marijuana?
I believe they did. It wasn't my residence, but I believe they did. I was remodeling it.
Thank you. And did you have access to that illicit substance?
I did. I purchased from Rocky Mountain High Awareness here in Gillette, Wyoming.
And did you know that it was marijuana?
I did. They sell it here.
With that, we would submit that as purpose of factual basis.
Ms. Gibbs, was there a test of the substance?
Your Honor, there was. I don't know if she'd be able to relay it. It did come back confirmed positive for THC Delta 9, Your Honor.
That is accurate, Your Honor. Thank you.
All right, Ms. Gibbs, is the state satisfied with the factual basis?
Yes, Your Honor.
All right, Mr. Hamlin, any reason the court should not accept your guilty plea?
No, ma'am.
All right, I'm going to find that you're alert, that you're not under the influence of any alcohol or drugs or any other intoxicant, nor suffering from any mental illness or deficiency. You're competent, your plea is made freely and voluntarily of your own free will and accord. The plea is made with a complete understanding of the charge pending and the possible consequences of your plea. That you knowingly and voluntarily waive the rights guaranteed by the constitutions of the United States and the state of Wyoming, that you are represented by counsel and satisfied with that representation. The plea was pursuant to a plea agreement. The terms have been announced to the court. I find there's a factual basis for the plea. I will accept it and adjudge it guilty of the charge. The court was reviewing the file here as I was going through the waiver of rights, and I do see here, looks like Mr. Hamlin was arrested on May 5th, bonded out on May 7th, so I have 3 days there, and then arrested on the bond revocation on, arrested on the bond revocation on September 3rd, bonded out, or bond was continued, on the 4th, so 2 more days. Does 5 days sound correct, Ms. Gibbs?
Yes, Your Honor.
Mr. McVeigh?
That is accurate, Your Honor. Thank you.
All right, Ms. Gibbs, anything further from the state on sentencing?
Your Honor, the state would just note that Mr. Hamlin does have one prior possession of controlled substance charge, but that was over 12 years ago. The state believes that this resolution is just and fair for Mr. Hamlin given his prior history and the facts laid out here today.
All right, thank you. Mr. McVeigh, anything further from the defense on sentencing?
Absolutely, Your Honor. I'm talking with my client. I understand his contentions and his desire for discovery, and we've secured that on the record today. And I know the state will come forward with that. Also talking with my client, I understand that he does have duties and a job. He is working, and it is an important thing that he be able to continue working. and he is here accepting responsibility, Your Honor. Obviously, the circumstances are what they are, but he is remorseful for the situation. He does apologize to the court and the state, and I understand that this is in the interest of justice. It is a fair agreement. We would ask that the court adopt the agreement as is, but also the understanding that my client is indigent, and obviously we would ask for the minimal of any type of fines, fees, and assessments. I would also say that under the Crime Victims Compensation Fund, this is not a crime of violence, and he does have an inability to pay, as he has an affidavit requesting the services of the public defender's office. Therefore, Your Honor, as the court has an immense amount of power in its deference and how it would like to proceed with any fines and fees pursuant to the plea agreement, I would ask that they be minimal, if non-existent. With that, Your Honor, I would also allow my client to allocute if he's so inclined, but I do want to continue that he's been a great client, maintained contact with me, and the circumstance that we are here before the court will render his bond revocation moot, and I would also ask that his bond be released back to him in total for purposes of his well-being, life, and his ability to continue on and not go down this rabbit hole again. Thank you so very much.
All right, thank you. All right, Mr. Hamlin, what do you want to tell me before I decide what to do in your case?
Well, ma'am, the house that I was working on, they had found the illegal substance. They had charged 2 people in the situation. I claim I take possession of anything that was found in the house to be mine. I was working remodeling the house, so it could have been mine. And I think that it's safe to say that it was mine. And other than that, yes, I do thank my attorney so very much, and I thank the state for I'm sorry that everybody has to be here just for me today in this situation, so thank you.
Okay. Well, Mr. Hamlin, marijuana is illegal in the state of Wyoming. It's illegal federally, so you need to keep that in mind moving forward, okay?
Yes, ma'am.
All right, the court's going to go along with the plea agreement in this case. With respect to the assessments, Mr. McVeigh, as I recall the statute, and I'm excluding the fine here, but as I recall the statute with respect to crime victim compensation, court costs, and court supervised treatment, the court here is required to order, unless I can make a finding that there is no current or future ability to make those payments, which the court cannot find. So I will need to order those assessments. The court here is going to order a $200 fine, $150 crime victim compensation fund, $50 court supervised treatment, $70 court costs. That's a total of $470. I'll impose a 30-day jail sentence. I will give you credit for 5. I'll suspend the remaining 25. Place you on 6 months of unsupervised probation. Terms and conditions of the probation will be that you violate no law, that you not possess or consume any illegal controlled substances, synthetic substances, or drug paraphernalia, that you not be in the presence of anyone using or possessing those items, and that you not be in any dispensaries or head shops. At the request of law enforcement, upon reasonable suspicion, that you submit to searches of your person, automobile, residence, or anything else within your dominion and control, and that you submit to the extraction of body substances for testing. You have $470 in fines, fees, and costs. How long do you need to get that paid?
May I just ask for 3 months, please? And I can make small payments on that, but...
Here's what I'll do. The holidays are coming up, so I'll give you until January 31st, 2026. If you need additional time to get that paid, you can contact the court, make that request, and it will get reviewed. However, I will tell you it's a lot easier to grant an extension if you're making some sort of effort to get that paid, all right?
Yes, ma'am.
All right, sir, you do have the right to appeal. An appeal must be filed within 30 days of entry of this order. If you cannot afford the cost of an appeal, you can request leave to file the appeal without paying a fee and to have a lawyer appointed. Do you understand your appeal rights?
Yes, ma'am.
All right, I will exonerate the bond. I'll relieve Mr. McVeigh of his appointment. Mr. McVeigh, would you like to review the order as to form?
Thank you, Your Honor. No necessary need to review. I would waive review of that as to form and approve it as to form as well.
All right, Ms. Gibbs, anything further from the state?
No, Your Honor, thank you.
Mr. McVeigh, anything further from the defense?
Just that I will be contacting the defendant here shortly after he accesses the court. Thank you, Your Honor.
All right, Mr. Hamlin, any questions of the court?
No, thank you all and God bless.
All right, court will be in recess. Thank you all.
All right.
Next one's not on team. Okay. Sorry. It's fine.